Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
Yeah.
Yes, Dr. Saraf.
But the matter relates to the Meghalaya cement case.
Yes.
That Lordship has already dealt with the matter by the judgment dated, which is Lordship filed at page 45.
Page 45.
Khan,
have you looked at it? He says governed by the previous decision. If it's that, we don't have to reinvent the wheel a second time?
Absolutely. Lordship,
We follow that?
Lordship, just received an instruction. So for the cancer-ring part is concerned, we had complied with the court's order. The second part of the order was 9/2/2022. We had to refund within 4 months. If not, 6% interest will be chargeable. Lordship, we need 2 weeks time to understand why this calculation was not paid.
I'm not on that earlier part.
In any case, Lordship, Lordship.
So the operative part is
don't refund the claim, cess claim within 4 months. We should be paying the same amount with 6% interest. So at this stage, Lordship, I'm making a submission. Kindly just grant us with 2 weeks time. We'll come back as to why.
very well.
My learned friend is, I think, in the petition. I'm not saying about that the time payment has not been made or made. This is not the petitioner. This is another petitioner. My learned friend is saying about the time limit of the making payment instructions. I'm not on that, Milord. This petitioner is not earlier petitioner. This is a petition, new petition which has been filed. I am only because you lost it. Lost it, page 51. Paragraph 17, Milord. The last 3 lines. The directions contained in this order for refund are confined only to present petitioners who had challenged the act prior to being repealed and before the GST regime came into place.
Where are you? Paragraph?
Paragraph 17, Milord, at page 51.
There is no paragraph 20 at page 51, sir. We have
paragraph 17, Milord, at page 51.
17. Relations are confined only to present petitioners who had challenged the act prior to it being repealed and before. So therefore, you say that you are one of the petitioners who had challenged it prior.
No.
You had not.
Earlier, I have not challenged it. My submission for Lordship is that, Milord, that your Lordship, once the act having been declared to be ultra-vires, then the whatever collection was made by the state was illegal and violative of Article 265 of the Constitution of India. Now, my Lord, once the act has been declared and the amount collected is illegal and unauthorized, then, my Lord, this direction that it will apply only in respect of the persons who have come before the court prior to repealing of the act, in my humble submission, my Lord, that will continue to Article 265 because, and your Lordship has not said that it will not apply. Your Lordship has only said, my Lord, that for the present, this petition order will apply only in respect of...
That is because of the doctrine of unjust enrichment. You have passed it on to your customers. So therefore, that's why we didn't consider it refund to you, and we asked only 20% to be refunded. And we added some kind of condition. Very well, let them file affidavits.
Because I'm the new petitioner.
Yes, it's a new petition.
It's a new petition, and who are not the petitioner? Who are not the petitioner earlier, not?
Very well. We follow. He just wants to take some instructions and file an affidavit.
My Lord, I'm not.
All the responses.
The petition is founded on an order dated February 9, 2022, by which the Meghalaya Cement Cess Act 2010 was found to be invalid, and the cess imposed thereunder found to be without due authority. Full stop. Paragraph. The state seeks some time to obtain instructions. Full stop. It appears that the present petitioner was not one of the entities which had challenged the Act prior to it being repealed and before the GST regime came into place. Full stop. However, the petitioner contends that once the Act was found to be invalid, the necessary relief would automatically accrue to the petitioner. Full stop. Paragraph. Affidavit in opposition be filed within 3 weeks. Reply thereto, if any, may be filed within a fortnight thereafter. The matter will appear 6 weeks hence.
I would like to know.
From the minutes, item number 1.
That I am opposing this appeal under section 37 of the Act. And I'm sorry, on the last occasion we were prevented from coming.
Yes, some flight,
We went to the airport and the Alliance Air pilots went on strike. So we had to come back. And there was no tickets on the immediate next flight of Indigo. So that's why we were here.
Yes.
Lord, there was a hydroelectric project being set up in Arunachal Pradesh in the Papumpari district.
In the?
Papumpari district, Milord. And Milord, we had to make a concrete gravity dam with spillways and Milord other ancillary works. Contract was for 3 years. It went on beyond 3 years. Here, Milord, we are concerned with the first 3 years. So I'm not, Milord, on the later history. Ultimately, work done. And Milord, I'm instructed, Milord, it was done, Milord, without a hitch. But it's these 3 years with which, Milord, we are concerned with. Now, total contract volume is approximately 148 crores. 48 crores was, Milord, paid to us for the work done. That's, Milord, clear from the award. The balance, Milord, is essentially money I would have been paid had I done the work or had I been permitted to do the work. So, Milord, we filed these claims restricted to the contract period and said that we have site office, head office overheads, we have labor cost, and we have certain other, Milord, incidental damages. These are expenses which we have incurred. So, therefore, for this period, we should be entitled to these costs which we have incurred. Had we been able to do the work, it's part of the price, so we would have got what we were entitled to.
You have no further claims other than this?
No, the other claims have been rejected and we have not accepted the rejection. Now, Milord, delay is admitted because parties would maintain a joint hindrance register, which the arbitrator also considered and the parties also accepted the position. In the joint hindrance register, it's clearly marked out as to which part of the delay is for us, because we are also responsible for a smaller portion of the delay, and which part of the delay is for the owner or the employer. After working this out, Lord, we made these claims that for the days for which the employer is responsible, for the days of delay for which the employer is responsible, my cost overrun should be paid back to me. For example, my site office and my head office overheads and my machinery hire and my labor cost. These are the essential claims. We succeeded, Milord, before the arbitrator. We succeeded before the Section 34 court. The two principal grounds are, Milord, urged today. Number one is that no interest could have been awarded at all because of a bar in the contract. And number two, there are restrictive clauses in the contract because of which the arbitrator should not have granted these claims and the Section 34 court also should not have accepted. From the records, what we find, Milord, in the statement of defense, Milord, really has nothing. And my learned friend also, Milord, attempted to show there is really nothing there. In the rejoinder, these clauses, Milord, are set out and these defenses have been taken. Now, yes, the defense has been taken. Now, in the arbitration, from the records we find, this was not argued before the arbitrator. Because the commercial court judgment clearly records that obviously this is not argued, notes of arguments are there, this is not argued. So therefore, you can't raise this issue now. On the earlier occasion, our first issue, Milord, we had indicated was that there's been a waiver under Section 4 of the Arbitration Act. If this was a matter which the arbitrator lacked authority to enter into, the second we filed our claims, you should have filed a Section 16 application, 16.3, and said that these are matters beyond the scope of the arbitrator. Having not done so, having filed a statement of defense, having taken a later plea in the rejoinder, not even explained it or asked for condonation of delay, and further having not argued these issues, it's not permissible for these matters to be raised at the Section 34 or appellate stage. That's not the first issue. Secondly, these restrictive clauses or no damage clauses, these, Milord, have been the subject matter of various proceedings. We, Milord, looked up and we found that they've been essentially, the learned judges have, Milord, essentially found these clauses to be inequitable. But these clauses being a part of the contract, they can't be rid of, Milord, immediately. There are three, Milord, schools of thought. Number one is the original argument before the English courts, which was also made before your Lordship, Milord, in PAM development, that if you are in breach of contract, damages follow. It is inequitable after committing breach of contract to come back and say that yes, I am in breach, but because of the clause in the contract, I should not be made liable in damages. So therefore, when there is breach, these clauses should dissolve. That's, Milord, one argument. The second way, Milord, where these clauses have been attempted to be watered down is that these really are a bar on the employer from admitting, accepting and making over claims for damages. These don't impinge upon the authority of the arbitrator or a court. Because courts have inherent rights, Milord, under the general law of the land to pass orders, having regard to the contract, but yes, because there's a breach, these clauses should not be considered. Thirdly, which is not relevant here, overrun periods, your lordships have found a way out of these clauses for the overrun period, saying that they don't really apply. Now there is a Supreme Court judgment, I must indicate, which is against us, which is earlier, I think 2009 or 2007. After that, there is a Supreme Court judgment which is in our favor. And in the recent past, there are at least 6 or 7 different judgments of the High Courts which, Milord, have looked into the matter and have permitted claims to go through. Your Lordship's judgment is there in PAM development from the Calcutta High Court. There is a Bombay judgment, there is a Delhi judgment, there is a Kerala judgment.
PAM development was carried to the Supreme Court.
PAM development was carried to the Supreme Court, so SLP rejected. There is a Delhi judgment carried to Supreme Court, SLP rejected. Several of these matters, Milord, have gone to Supreme Court, SLPs have been rejected. And a very important argument which, Milord, has persuaded your Lordships is that if this is a matter which is in the domain of the arbitrator, whether he'll take note of these clauses, whether he'll look at breach and forget about the clauses. Now, this is not a matter which really falls within the domain of the Section 34 court or, Milord, the Section 37 court.
You see, in the regime of that interest thing, that French sounding name.
D-Space.
Engineers D-Space.
Yes.
In in the light of engineers the space and the reasoning, it could have been. But with Ambika, that is no longer now a thing. Plus, you'll find the first of this line of cases is GC Roy.
Yes, that's under the old Act.
Under the old Act, but first of these cases is GC Roy. And GC Roy, the underlying thing over here is that the arbitrator is bound by the contract and cannot do. In fact, even the judgment that opened up Section 34, so to say, your
Saw pipes.
ONGC saw pipes. That also goes into that, and not only into that, relies on Section 28 to go into the provisions of the Contract Act and other laws that are prevalent. Plus, there is a concept of party autonomy now.
Yes.
To what extent do courts or arbitrators interfere with clauses of contract entered into by the parties without any objection?
If the claim, Milord, the overriding thing is, Milord, that if it is shocking.
And again, your argument is confined to the claimant damages. On interest, you don't have any argument.
Interest, Milord, pendentility interest, I don't think I should argue.
No, only future interest you can get.
Yes.
Because on future interest, there can be no curb.
Yes. So pendentility, I won't waste your lordship's time.
Yes.
And for the other.
Like paragraph 36 of Ambika being interpreted otherwise by Justice Chandrachud.
Yes, in that recent judgment which has come.
Not recent.
So there is a very recent judgment of Justice Chandrachud also. So that is there. But two things, Milord. Firstly, Section 20, because of the saw pipes interpretation of Section 28, the section itself went through a change. Earlier it used to be in accordance with the terms of the contract. Now it is having regard to the terms of the contract. So further leeway has been given. So it's not that the arbitrator's hands are bound completely. Though this is a matter which will be governed by the pre-15 1996 Act.
So in accordance with.
In accordance. Indicating.
No. Of course. No, you have to honestly put the cards on the table and then
argue. Otherwise, there's no point.
Deceit is not part of advocacy.
No. That's one disadvantage I have. The second disadvantage I have is, even though it has not been cited, I must cite the Supreme Court judgment against me and then get out of it, if I can. The biggest hurdle is if your lordships feel that the claim would shock your lordship's conscience. I must get out of that first, because I must show your lordship that this is a genuine claim.
Let us start with 34 as it stood.
Yes.
Get a pre-2015 amendment of the 34 Act. We'll get it in the new Act itself that indicates what was the amendment. And tell us the limbs that you want to rely on. Because his challenge has to be squarely within 34. 34.2. Squarely within 34.2. If you can show that he does not come under any of the limbs in 34.2, then you're out.
Not really speaking, Lord A doesn't apply. Doesn't apply. B is applicable. B1, BI. An arbitral award, Section 2, Section 34, subsection 2, an arbitral award may be set aside by the court only if the court finds that I, the subject matter of the dispute, is not capable of settlement by arbitration.
Where are you reading?
Below Section 34 2B.
2B, yes.
This is like a minefield.
A won't apply.
A won't apply.
B, yes.
It's BI, subject matter of the dispute is not capable of settlement by arbitration under the law for the time being in force.
No, that's not the case. It's II.
It's II. Arbitral award is in conflict with public policy of India. Now, what is the explanations have been slightly altered. So, the earlier explanation was, without prejudice to the generality of subclause II, it is hereby declared for the avoidance of any doubt that an award is in conflict with the public policy of India if the making of the award was induced or affected by fraud or corruption or was in violation of section 75 or section 81. This is Milord, I'll end up making I'll end up making a mistake. I'll just check the unamended section 34.
No, because all this has been 2 and 3 have been introduced.
Yes.
It is in contravention of the fundamental policy of Indian law. It is in conflict with most basic notions of morality or justice. Then second, for the avoidance of doubt, the test as to whether there is a contravention of the fundamental policy shall not entail a review on merits of the dispute.
Yes, Milord. But this part has, I am reading, Milord, the footnote, what I placed was, Milord, the footnote in my book, which is also a recent book. I'll, Milord, take out the unamended provision and place it again. But it is public policy as per the unamended act, which would really...
And as you know, there was a distinction made in public policy. What amounts to public policy under this act and what amounts to public policy under Section 3 of the Foreign Awards Act.
That is, Milord, it was much more restricted at that point of time. It's now been expanded. So, Milord,
I think you'll find that in
Western Gecko and
Western Gecko and
that
Sasong or something.
The Sangyong, Milord, explains Western Gecko,
Associated Builders, paragraph 17.
Yes, and then Milord, Sangyong says that after the amending act came in, Milord, what part of associated remains, and after amendment, how it is to be read, Milord, is there in Sangyong. So that's, Milord, very clear on. I'll just read out the unamended portions. Now, this is a matter which was, Milord, considered quite extensively in your Lordship's judgment in, Milord, PAM development. If your Lordship permits me to place those paragraphs, it's, Milord, completely discussed and decided there. The PAM development. I just place those portions of PAM development.
But before that, Ms. Chaudhary, on facts,
Yes.
bring us to the clauses
Yes.
which are asserted. Two grounds. One is clauses barring
One,
claim and damages,
no, clause 55,
and the second is
clause 24.
interest prohibited.
Yes.
Now, as to claim in damages being barred, there's clause 55.
Yes, there's clause 55, there's clause 24, subclause 7, clause 74, E, and there is clause 70, subclause 9.
74E.
74E,
Capital E or small?
small.
And
70, subclause 9.
So let us see these clauses.
Yes, Milord.
And let us see your claim.
Kindly take the contract which starts from page 159. First, my lord, is clause 24, which is at page 200. No, it's subclause 7 is at page 200. Clause 24 starts from 198. It's completion time and extension, and then 200 is subclause 7. No compensation is admissible other than whatever provided for in the clause number 20, suspension of work for any extension of time if granted.
For any extension of time if granted.
So this is confined to
Extension of time.
extension of time.
And my argument here is this is not on extension of time, this is on the original contract period.
That will come to when you come to the claims. So this is page 200, 24/7.
Next is, my lord, 55.
No compensation for extension of time. Then is
Page 238.
55.
Time for payment and interest. No claims for interest or damages will be entertained by the corporation with respect to any money or balance which may be lying with the corporation owing to any dispute, difference or misunderstanding between the engineer in charge on the one hand and the contractor on the other, or with respect to any delay on the part of the engineer in charge making periodical or final payments or any other respect whatsoever. So this is entertained by the corporation. That's clause 55.
Again, it is confined to
Dispute.
It is confined to interest is probably, this is it, there may be some other special clause for interest, but no claim for interest
Or damages.
or damages. Because interest is, by its very nature, is in the form of damages. It's for compensating you for receiving the money later by ensuring that the money that you receive later is added on to so that you can buy the same basket of goods and services that you could have bought if you had been paid the money in time.
In time.
This is the compendious way of describing interest. I think I've laid it down several times. It's in economics.
Economics.
Yeah.
So that is, and it's also with respect to a misunderstanding or dispute
So
or difference.
it's on with respect to money or balance or payments.
Yes.
It is confined to that.
Yes.
It is not a blanket prohibition on damages. It's
Which is-
only confined to
Yes, delayed payment.
And again you say it's prefaced by to be entertained by the corporation. So the embargo is on the corporation, not on anybody.
Yes. And that this is further made clear from the last line because it's regarding periodical and final payment. So that's makes it very clear. Now the third clause, is clause 70, subclause 9 at page 250.
9 is IX.
Yes. It's an interesting clause. It 250. It creates two separate embargoes. The first sentence is that the arbitrator appointed shall have no power to award interest on any claim referred to the arbitration. So, this is only for interest.
To the arbitration.
Now, the second limb is no claims for interest or damages on whatsoever count will be entertained again by the corporation with respect to any dispute, difference or misunderstanding between the corporation and the contractor.
Again, corporation, no arbitrator.
So, my lord, the restricted authority of the arbitrator
Now we have one more clause left before you start analyzing
Yes.
it. We have one more clause left.
which is 261. That's clause 74. No claim whatsoever for price adjustment variation other than those stipulated above shall be entertained. And if your lordship looks at clause 74, which starts at 258, it's on price adjustment and variation. And the restriction reads, no claim whatsoever for price adjustment or variation other than those stipulated above shall be entertained.
Payment to contractor for work done shall be adjusted for increase or decrease in local currency, cost of
Cost
labor.
of labor, material and high-speed diesel.
Was this a global contract?
I think so, Lord. I'm not sure, Lord.
Local currency, cost of labor.
Or Lord, copied from a global contract.
Yes, your
Either of the
contract is
two.
in rupee terms. If your contract
It's
is
a
in
rupee
terms,
contract.
then material and high-speed diesel,
Except for those materials supplied by the corporation according to the procedure mentioned
this is
hereunder.
confined to only that price adjustment and variation.
Yes.
And pertaining to those items which are covered by it.
Yes.
It does not cover anything beyond it.
Beyond that.
These are the only clauses.
These are the
cited?
only clauses. These are
No
the-
other clause cited.
No other clauses. Now, my lord, my claims.
Yes.
If your lordship looks at the statement of claim, which is at page 268.
Yes.
Kindly have a look at page 298, which is the relief portion. Claim 1 is for 298, Lord, internal page 30 of the statement of claim. Claim 1 is for reimbursement of additional cost expenses incurred during the period since inception till 30th June 2011.
Was that the scheduled date of closure of the contract?
Not even before that. The contract would have continued till 30th August 2012.
Contract period from when to when?
Lord, it's,
31st.
Lord, I'll indicate the letter of intent date, which is 31st August 2009, and the contract would run for 36 months from the date of issuance of the LOI, which is 36 months from 31st August 2009, running up to 30th August 2012.
No. Running up to 31st August 2012. Because this is in months, not in days. So you have to calculate the whole month.
That date is my calculation.
No. It's not for 3 years, it's not for
365 days.
365 into 3, it's for 36 months.
36 months. So end of the month.
End of that month.
Now that claim 2, this was a 40 crore claim. Claim 2 was reimbursement of entry tax. Claim 3 was payment of cost of reinforcement steel used in precast RCC lagging. Claim 2 and Claim 3 have both been rejected by the arbitrator. And it's
So
not an issue.
reimbursement of additional cost expenses incurred during period. Now let us see the,
And 23 crores out of this 40 crores is awarded.
flat 23.
No, I'll give the
So 23 plus.
23 plus.
Now show us the details of the claim.
Yes. In fact, the award contains a schedule
We'll come to that. First let us see the details of the claim.
in the statement of claim.
Yes, to rule it out from the operation of the restrictive clauses.
Yes. 274. And then 287.
287 is the chart.
Yes.
Let's look at the chart.
It's this is, if your lordship takes 287, I'll indicate serial numbers 1 to 5 have been accepted.
1 to 5 accepted.
Yes.
In full.
No. In part.
In part.
In part. But the higher charges of DG sets is rejected. And the service tax WCT.
So that comes to 9 and 7, 16, 17, 18, 19, 25. Out of 25, you got about 23 plus.
Yes.
And expressly rejecting the head 6 to 17.
Yes. Nothing's come from there. Now,
So
what happened in the arbitration was that to ascertain the delay or the causes of the delay, the hindrance register was taken up for consideration, and the parties, my lord, accepted that position because it's signed by both the parties. So, my lord, the claim was made on this basis that for every month during this period of 2 years, we took out the month, we knew how much of work had to be done. Say, for example, in January of 2011, there was requirement to do, the target was 100 rupees, and we did work worth 20 rupees, and 80 rupees work was not done. Now that 80 rupees work, we then went into how much of it was because of us and how much of it was because of them.
Apportioning.
Apportioning it. And only for work which couldn't be done because of them was the claim made. Now they participated in this process.
Now we follow heads 2, 3, 4 and 5.
Yes.
Underutilization of officers, staff, underutilization of labor, revenue expense, site overhead.
Yes.
And
head office overhead.
unachieved work.
Yes. Head office overhead.
But what we don't understand is, where does cost on account of ownership and plant and machinery come?
This is hiring of equipment. The usual, for example, if I obtain some excavators from Shrey for the purpose of this.
Why have we said cost on account of ownership of plant and machinery? Where have we described this?
All documents were produced.
No, we won't go into the evidence. We'll go into your claim and we'll go into how the arbitrator treats the head of claim.
The statement of claim doesn't further describe the claims. It doesn't. But there was an exhaustive notes of argument, written submissions filed, which would reflect what was argued and which would reflect the documents produced.
No. Let us see from 274 onwards. Claim 1. Claimant was awarded so and so 36 months, therefore by 30th August.
Yes.
Pursuant to issue, a claimant immediately began mobilizing on 17th September. Claimant on execution which was approved. 11 June, claimant submitted revised construction without changing date of completion. Except either respondent repeated defaulted on contrary obligation to provide free site, access to site, construction drawing, instructions also received which were not part of the scope. The delays caused on account of each of the aforesaid factors detailed below entitled claimant to seek EOT. What is that?
Extension of time.
For completion of work in terms of clause 24. Mobile resources remain underutilized because of the grievance. The client was also entitled to be compensated the costs therefore.
Lord, Your Lordship's query would be answered by paragraph 93 at page 286. There's one sentence there, but that is what we have. And the documents.
Paragraph 93.
Paragraph 93, the claimant has, at page 286, the claimant has quantified its additional costs by calculating its number one, total ownership costs of plant and machinery as per CWC guidelines.
What is CWC?
The Central Works Commission, I think.
Underutilization factor of 68%.
Yes, that is what it came to. And there's a detailed calculation for that given and accepted by the underutilization, which is below the delay really, is an accepted position because the arbitrator invited comments, looked at the hindrance register, gave them a chance, they filed a statement, they gave another criticism, some of which was accepted, some not, and ultimately the quantification was arrived at. And huge disclosures made for these claims, which were considered by the arbitrator. In fact, there are two pleadings filed in the course of arbitration by the employer.
Yes.
Which criticizes our computations, which are on record. If your lordships see that, it will be very clear. One is at page 405. This is a comment or a reply of the respondent on the quantification of claim 1. In the arbitration, there was an order passed directing the respondent to submit comments on the quantification, even beyond the statement of defense. And my lord, this comes out. Now, my lord, kindly see the objections. See, it starts from 407. And my lord, there is a detailed analysis by the respondent. So first is the arrival date was considered, then additional time of 7 days has been added for inspection and clearance by the QC and A wing of HCC, then maximum 21 days has been considered, etc., etc. Then he suggested an average utilization factor of 75%. Then at page 408, a reduction factor. And they, my lord, at page 411, which is referred to at 410, suggested a quantification chart and said that your claims are inflated by about 75%. Now that's at 411. So 411, my lord, is their calculation. This again was considered, I'm sorry. And I'm sorry.
What is 411?
411 is a calculation on
the Pare hydroelectric project.
Yes. This is a calculation prepared by them, by the respondent.
How can their calculation be more than yours?
Now this is
2 crore.
Compared to 287?
no, this is 2 crores.
2 crore.
This is 2 crores.
Lakhs. It is not 20 crore.
Oh, so they've brought it down by 75%. And there is a further document which is quite interesting. Kindly see page 415.
One, two, three. Let us see which is they deny. We'll come to that. Just
kindly see 415.
Just 1 second,
Yes.
please. Cost of ownership, plant and machinery. This is equal to 1. Underutilization of labor equal to 2. Our revenue, staff, expenses, overhead is equal to 2 plus 4. Now, labor is 3. This is equal to 2 plus 4. Unachieved work is not given.
Yes, but 4 onwards, Milord.
And they have admitted DG sets. Why did the arbitrator deny it?
Arbitrator rejected it, Milord. I got the reason to keep the Now there is further, Milord, statements from the
Now
respondent.
in the comments pertaining to the claim, there is no caveat that without prejudice that this is not maintainable.
No. Even in arguments it wasn't there. Then, Milord, they go into the merits of each claim further. The respondent goes into the merits of each claim further at page 415. Milord, paragraph 1. Oh, my mistake. Milord, I'm sorry, Milord, DG sets is my mistake. DG sets has been awarded.
Has been awarded.
It's my mistake. For some reason, I thought that DG sets. Oh, NPV has not been, that net present value has not been considered. It's my mistake, Milord. আমার কিরম লেখা আছে ডিজি সেটস দেয়নি আমি if your lordship
Just a second.
I'm sorry
Now, if you see 7 of course is total, 8 is service tax. So has he declined service tax, WCT, labor cess?
with my
They are all incidental to the previous claim.
yes. So I've got ownership cost of equipment, then cost of labor.
We'll come to the award to see what actually is.
That's at page 88.
1 to 6 partly allowed. Yes, now you were at page 415.
415. There is further discussion in the arbitration on quantification, and at 415 they file a statement. The covering letter is at page 414.
No, that's all right.
Then kindly see, in terms of the above referred arbitral tribunal's order, comments are offered with respect to specific points of quantification of the claim. there are certain points in the SOC, including Annexure B, B1 and C, which are found to be conceptually wrong in relation to the claim and thereby resulted in highly inflated claim. Details of the comments are as follows. Under paragraph 87 of the SOC, the claimant claimed that its resources were underutilized by a reduction factor of 68% during the aforesaid period. Calculation of RF was carried out under Annexure B, page 35 of SOC. For claims as stated below, the methodology adopted by the claimant in determination is conceptually wrong and will not indicate. Like, for example, 1, which is delays for hindrances which are not attributable to the claimant and which are the root causes of underutilization, are totally ignored. Now, this was ultimately taken care of when we filed a revised statement, which is recorded in the award. Then below, the next one is, by giving credit to the respondent, the value of the work affected due to delay on account of the claimant, column C such and such, and went on to determine the RF based on the credit. Then mere recording of hindrances by the claimant and acceptance by the respondent does not reflect the true loss on productivity of workforce and plant and machineries. And this way it goes on. Now, if your lordships come to below page 418. In bold, in view of the above, the respondent opposed the concept of determination of reduction factor based on the hindrances attributable to the claimant. For reasons as stated below, the respondent felt that the methodology of determination of reduction factor based on hindrances attributable to the respondent is a correct methodology. Complete participation. And this is what was ultimately considered. Paragraph 3. There have been hindrances in execution of the work for reasons attributable to the respondent.
Let's forget it. Let's come now to the award.
Now just one more, I'll just indicate on the next page, which is 419.
5.
No, my lord, I had kindly 418, my lord. First is that they suggest what is a correct method, and at 419 they record that they were required to file, and they did file a chart, and they were required to file a further chart, which they did not. Now my lord, the award.
Where is that?
419. 419. Not at the bottom, my lord.
Yes.
Annexure B shall stand corrected, and corrected annexure to be submitted by 8th August. They don't, my lord, submit this. Now
so their argument is that the hindrance register that you referred to should be read and to imply that only delay attributable to the employer should be held against the employer.
Yes.
And what you've done is you have excluded delay attributable to the contractor. So you included delay attributable to the employer plus delay beyond
that
control.
Which, my lord,
which is something that we can't go into.
And we took care of it. We left out all this. And the arbitrator made us give a further statement. On the next page, your lordships will find by 8th of August 15, both parties had to file further statements taking into account their objection. We filed, toned down our claims. They did not file, and what we filed was awarded by the arbitrator.
Where is that? Where is what you filed?
The next page itself. 419.
No, 419 is still part of theirs.
Oh, lordship wants to see the list.
No, where is your toned down claim?
That, my lord, they have not annexed. But we have brought our written submissions, which has it, and the arbitrator has essentially reproduced it and made it a part of the award as an annexure.
We'll look at it from the award.
And I'll show this.
We'll look at it from the award.
Yes. Yes. And I'll show my notes of argument, which not is exclusively really on this, how it was worked out. And the award also contains list of documents submitted, so that records it. Now, will you kindly take the award, which is at page 59. In the course of the arbitration itself, most of the issues were resolved because of the procedure followed. Now the award, the first 4 paragraphs are recording of what had happened. And paragraph 4 is pleadings of the claimant, page 64.
Sole arbitrator?
Sole arbitrator.
What is the date of the award?
Date of the 15th September 2015. Page 64 is from where pleadings of the claimant are considered. Page 67.
Award ends at where?
Award ends at page 93.
93?
No.
98.
Yes, 98. After that are the annexures, which contain the quantification.
Yes.
Now, look, page 64 is where pleadings are discussed, claimant's pleadings.
Yes.
Page 67, III, last 3 lines. We mentioned that the parties have jointly verified the disruptions caused to the work based on hindrance register and contemporaneous records, and final agreed delay days have been signed by the parties. And then page 68, quantification, 4.1.2. A to F are the heads of claim. And page 69 is how it was worked out. Firstly, the underutilization has been worked out every month on the basis of actual execution of work in rupees against the monthly financial targets as indicated in the contract bid at page 358 and as per annexure such and such. Then monthly costs on the above mentioned subheads have been worked out for normal working as per construction schedule. Additional cost incurred by the claimant has thereafter been worked out by multiplying the costs worked out with the underutilization factor every month from annexure B. These computations are contained in these volumes. Some details. So we got the details of cost of plant, equipment, etc. What is depreciation? How many overheads were looked at? All that is given. Ends at page 70. I'm omitting pages 71 to 70 and 72 because those are in respect of claims 2 and 3. Then lot page 73.
Claims?
I'm sorry, page 73 is pleading of the respondent. So the entire pleading is, their case is summarized up to page 78, and then the respondent's case on quantification is summarized from page 78. Then paragraph 5.1.2, respondent's case on quantification, ABC, then C, I, the respondent disagreed with the method of the claimant, which your lordship has seen, then II. The respondent has worked out such details, annexure B of the document
Please
dated.
come to 5.1.2C.
Yes.
Without prejudice, the basic stand of the respondent about the non-admissibility of the claim.
Claims.
Now, where is the admissibility of the claim decided by the arbitrator?
Now, the non-admissibility is not on the clauses. It is because of what is before. The claimant has been fully compensated in the form of paid price adjustment in the extended period of the contract. The claim is not justified at all. It is to be established as to which party has violated the contract provisions. The respondent has fulfilled all contractual obligations, but the claimant did not put adequate resources, resulting in time overrun and losses to the project. So this is the basic stand. And this is why it's said to be non-admissible, not because of the clauses.
No, what is this? Pleadings of the respondent.
Yes.
5.2.
Yes.
Yes.
That's correct. My learned friend points out, Milord, if your lordship looks at page 73 once,
Yes.
he uses the word admissibility as, Milord, in a looser sense. Milord, 5.1.1, pleadings of the respondent. 5.1.1, admissibility of the claims. And he discusses that the respondent has handed over work fronts in time. This is on merits.
Yes.
So that's not the... And below, page 80, subparagraph 5, the respondent submitted his written submissions on 6th August 2015 without prejudice to their basic stand on the inadmissibility of the total claim. That's not considered.
Where?
Not
Clause 5.
yes. Now, Milord, he looks at final rebuttal and then appraisal by the arbitral tribunal starts from
Page 84.
84. In fact, I would request your lordships to see page 83, paragraph 6. As decided with the agreement of both parties, the written submissions of each party were sent to the opposite party on 18th August after receipt of submission from the respondent on 17th August. The final rebuttal from the claimant dated 25th August has been received on 26th August by the arbitral tribunal, wherein the claimant has made its submissions limited to the following. During the meeting held on 9th July 2015, arbitral tribunal had granted liberty to the respondent to resubmit corrected quantification which were originally filed by the respondent on 3rd June 2015. After making corrections in respect of the errors and discrepancies therein that had been pointed out by the arbitral tribunal and claimant during its rejoinder arguments and agreed to by the respondent. The claimant was thereafter provided an opportunity by the tribunal to give comments on such revised quantifications of the respondent. However, the respondent has chosen not to file the corrected annexures.
The points taken about those clauses Are they found in the written submission?
Yes.
Is
Yeah,
that
I
what
have
is
them.
referred to at paragraph II at page 84?
Paragraph II.
At page
Bakul,
84.
written submission, Bakul. I'll just check once.
Written submission.
I'll just check. 436. If your lordships look at page 436.
14, 15 and 19.
Yes. 436, Lord. Proceedings 7 such and such.
For 36.
Yes.
Paragraph 14, 15.
14 is at 441. Then 15. These are new issues.
There is reference
No,
to
Milord,
clause 24 and 74.
Yes, but somehow, my lord, I may be wrong, but maybe there is, my lord, another written submission. I really don't know. I learned it. I've asked. It's we couldn't trace out, but
Where have you taken the objections,
Only
Mr.
this written
only this.
Only in this.
That's better for me.
All my instructions are there.
Very good. Thank you.
Better
very
for
fair.
me. Now, my lord, paragraph 18 is what your lordship may look at.
Yes, 24 and 74.
Yes, 24. So this is a different argument. This argument is that I will give you extension of time and you will ultimately get escalation. So therefore you are not entitled to get anything else. That's been rejected. That's a separate argument. So this is their my lord, written submission. Now, my lord, to come back to the award, after the final rebuttal from page 84, appraisal by the arbitral tribunal, claim 1 starts at the bottom of the page.
Page
Page 84, my lord, claim 1 starts at the bottom of the page.
84, appraisal.
Yes. At 85, there is no dispute between the parties with regard to the loss of days in working production during execution of the work, which have been clearly identified as attributable to the claimant or the respondent. This exercise has been carried out on all work fronts. The claimant has worked out the factor of underutilization of its resources based on delays not attributable to HCC after giving credit for the days lost on their account. This was objected to by the respondent since loss of productivity might involve so many other factors in execution stage. The respondent considered the underutilization only due to factors attributable directly to the respondent. The same has been agreed to by the claimant, who finally resubmitted their modified computations after more or less accepting and meeting out the respondent's considerations and objections under various subheads of the claim. It cannot be disputed, so will not be accepted. It cannot be disputed that due to the underutilization of resources, the actual production had been much less than originally planned while bidding for the work, and so resulted in financial losses to the claimant. The losses which have been claimed under various subheads are dealt with as follows, as below. Ownership cost of equipment corrected as per paragraph such and such, then inspection, vehicle, repair and maintenance charges, then cost of labor, etc. Then subparagraph 4 at page 86. The argument of the respondent that for delays caused on account of the respondent, the claimant has been fully compensated as per the contract provision, that is by way of EOT and price adjustment, is not correct. Price adjustment certainly does not cover any losses due to delays, hindrances caused on account of the employer. This is where this argument was dealt with. The Indian Contract Act is also clear in this respect, particularly sections 55 and 73. Once there is breach of contract by the respondent, the claimant is entitled to be compensated for the losses, damages suffered by the claimant. This position of law clearly set out in the case of such and such, wherein the Delhi High Court held petitioner could not be expected to perform its promises until and unless the respondent was willing to perform its reciprocal promises. In view of the provisions of section 54 and 55 of the Contract Act, the petitioner was entitled to claim compensation for any losses which it may have sustained. Similarly, in the case of Punjab National Bank, the Delhi High Court, while dealing with the argument that there were contractual provisions that barred the contractor's claims, despite defaults on the part of the owner, held that the clauses of a contract cannot possibly foreclose a claim by the contractor for damages as a result of delay not attributable to the contractor. So this is a judgment of the Delhi High Court, which was which was not set aside up to Supreme Court, and it deals with this issue of barred claims. In view of the foregoing details, the AT is of the considered opinion that in this particular case, where the breaches resulted in a reduced progress to almost 32% of the scheduled target, the claimant is genuinely and legitimately entitled to be compensated for the losses, damages sustained due to underutilization of plant and machinery and labor, etc. There is quantification of claims. As far as planned value of the work is concerned, the value of the work of rupees such and such was for 144 crores was envisaged in the contract. As far as the value of work executed is concerned, it comes to rupees 46.27 crores on the basis of RA bills. So the value of the work lost due to delay is attributable to the respondent, claimant, and beyond the control of both the parties is rupees 98 crores. AT has noted that the claimant has quantified its claim in SOC based on the value of work lost for reasons other than due to Hindustan Construction Company by giving credit of rupees 20.16 crores. That is the calculation in the quantification. As per the quantification provided by the respondent on 3rd June 2015, that is computation of reduction factor based on the projected value of the work to be performed as per the work program and the value of the work affected due to hindrances which were attributable solely to the respondent. The statement of the respondent had grave errors related to the delays mentioned in the joint hindrance records and the other mathematical errors also. Both parties were directed to resubmit the corrected statement. However, the respondent did not submit the same. The claimant has submitted corrected quantification as per the above mentioned method in its written submissions dated 8th August as Annexure A in Volume 2, after making corrections in respect of errors and discrepancies pointed out by the AT and claimant and taking into account the other objections raised by the respondent. It is noted that the value of work due to delays attributable to the respondent comes to rupees 71.35 crores. AT has gone through this corrected quantification and AT has found them in order. Based on the same, AT has noted that as per the value of work lost due to the delays attributable only to the respondent, quantified based on the delays mentioned in the joint hindrance records, is rupees 71.35 crores against rupees 78.24 crores considered by the claimant in the SOC. Based on the above considerations, AT has come to the conclusion.
Once he comes to 71.35 crore, how has he come to 23.12?
Yes, this is the unachieved work. From this, the percentage is getting worked out.
How?
The reduction factor. So, my lord, if your lordship see 71.35 crores is a certain percentage of 90. Now that percentage 90 is, my lord, the balance work which had to be done in terms of the contract. And that percentage is worked out and put to every month's target, and this computation is done. It's been given in page 95.
Yes.
Percentage of 144 really. Part done, part not done. 95 is this summary. So, below, serial number 1 is the month of, it's October 2009.
Yes.
Reduction, second is reduction factor after corrections, volume such and such of written submissions, 100%. Equipment ownership cost is this. Then officer and staff cost, labor, overheads is nothing. Because at that time possibly there was nothing. Now, so the total of underutilization is equipment cost, which is zero used, 241.
Where?
That, right at the end. It's clearer from the next month where everything had started. Next is November. In fact, yes, 52.56% is the reduction factor. So, from the target which was set to be achieved in terms of the contract, 52.56% less work has been done. Now, the ownership equipment cost is this, then each of the costs are given. Now, the ownership equipment cost, if you apply 52.56% to 791, I think one would get 415. So, my lord, the underutilization, simply put, my lord.
Where is 415?
My lord, kindly take the serial number 2. Serial number 2, column month is 30th November 2009. Next is the underutilization, 52.56. Then you apply it on equipment cost, staff cost, labor cost, overheads at site plus rentals. So, if the contract had been performed completely, I would have got this, the underutilization for which I am not responsible is 52%. So, therefore, I am entitled to 52% of 415. of 791, which is 415, which is on the right hand side. So there are two things, my lord, which have been done before this schedule was considered by the arbitrator. Number one is delays on account of the respondent and delays on account of other factors were left out. After that, it was discovered that in the month of November 2009, 52.56% work could not be done because of their fault. Now, that 52.56% is applied to each of the four heads, which have been separately quantified with supportings and established. So that's how I get the underutilization. All the respondents' objections were considered, and this is the final schedule. So their objections were principally with respect to this percentage, which is in the second column. That is considered. It's quite forensically done, and taking into account their beloved objections.
Yes.
And this is how, my lord, it was worked out. And this is, my lord, the claim. Now, thereafter, my lord, pages 89 onwards. Are, my lord, not relevant because claims have been rejected. Interest is dealt with at page 92. Here, my lord, I am making no argument on the pendentility interest. But on interest, I have a further submission. If your lordship looks at their statement of defense, and I'll read out. Claimant is required to pay an amount of rupees such and such only, along with the applicable interest on it to the corporation. Now the restrictive clause says that arbitrator has no jurisdiction to grant interest. In the statement of defense, where the respondent itself claims interest, in my humble submission, it should not be permitted to have any advantage. Now, my lord, this being the award, matter went before the commercial court. Commercial court considers the judgment of the commercial court is at page
99.
99. This is when, my lord, the challenge comes at page 104.
This is 3rd of November.
Yes. This is 25th October 2022. The reasons, my lord, are from 116, but the contention of the appellant before the commercial court is at page 104. The petitioner has challenged the impugned award on claim number 1 and interest awarded thereon, both for pre-award and post-award period, as contrary to the specific stipulations of the contract agreement as provided in such and such. So these clauses, were relied upon. Then on the next page, page 105, paragraph 11. Again, clauses were relied upon. Our response, is from page 107. First argument was that this is beyond the scope of section 34. Now, page 108. Last 5 lines. In the instant case, the parties had mutually agreed and signed joint statements identifying the clauses for page 108, last 5 lines are contentions.
Just to like the conduct of parties.
Yes, the conduct of parties is also a relevant factor in the matter of construction of a contract. In the instant case, the parties had mutually agreed and signed joint statements identifying the clauses for delay to the work. These signed delay statements available at claimant's documents were part of the records placed before the Honorable Tribunal and were submitted by both the parties. Then judgments are noted. Finally, page 116, decision and reasons. Having gone through the record and arguments and submissions made by both the parties and the award published by the arbitrator, this court deems fit and proper to analyze the key legal principles relating to the scope of section 34. I am not, rereading these judgments. No, I am sorry, I must have missed something.
Which has not been used before the arbitrator.
Back about it. Section 34 scope is considered. Then, page 122. And the court comes to the conclusion that it's a balanced view. Then we'll have page 122. Paragraph 37. First and foremost, it is crucial to point out that the petitioner in its wisdom and for the reasons best known to it did not choose to make any submissions and arguments before the arbitrator challenging the power of the tribunal to grant pre-award and post-award interest in view of the negative interest clauses under the contract. This being the position of the petitioner, even though the respondent has specifically demanded interest on the claim amount in its statement of claim, neither clause 55 and 70 nor implication arising therefrom has sought to be stressed upon and argued by the petitioner under the instant petition, was relied upon and contested before the tribunal. I will not add to it. I'll say that they have asked for this. Rather, no case whatsoever in this regard was made out before the arbitrator. The arbitrator, in all fairness, was not taken through any of such contractual provisions by the petitioner, and thus he never had the occasion to dwell into this aspect. So even the written submissions which we have placed doesn't, contain any argument to the effect that these no damage and restrictive clauses were operative.
In fact, no submission made, page 113 to be done.
And at page 113, is our submission, paragraph 26. The respondent also submitted that the petitioner for the very first time in the instant petition has taken the plea that in terms of the third part of section 55 of the Contract Act, respondent cannot claim any compensation as there is nothing on record to show. This is regarding a letter which was thereafter permitted to be produced. It is basic principle of law, such and such. And then, my lord, interest is considered. And paragraph 42, the court, my lord, notes that while allowing claim 1, all documents and evidence was dealt with and examined by the arbitral tribunal, and revised computations meeting their objections was filed, and therefore this order was passed. Now, paragraph 44 is important. Paragraph 44 proceeds on the basis that thus in view of above, the petitioners challenge that the award is contrary to clause 24(7) and clause 74(e) of the condition of contract agreement, holds no water and is not sustainable. Even otherwise, as per the decision of the Delhi High Court in such and such, it has been held that contractual clauses that bar a claim for damages arising from the breach would be void. The provisions of the contract which set at naught the legislative intendment of the Contract Act would be void and against public policy. And several judgments were, my lord, considered. Now this is, and there is a further finding that since there is no clear and specific bar on the grant of compensation or damages by the arbitrator in the instant case, the arbitrator was free and well within its powers under the law to grant compensation or costs under the law to the respondent. So on both counts, A, these clauses are void when you commit breach, and B, these clauses are only operative on the arbitrator and not on the corporation and not on the arbitrator. Both arguments are considered, which is essentially the law, my lord, laid down by the honorable courts, the honorable high courts.
By they are asking the interest they are given a go by, given a checking for that, please.
So, my lord, the paragraph 43 is where the quantification is considered by the commercial court, and the fact that a revised statement was filed is taken into consideration. Paragraph 45 is that there is no bar for the arbitrator, and paragraph 44 is that these no damage clauses really hold no bar. Now this is another, my lord, parallel school of thought, that these no damages clause, even though contained in printed contracts and signed by the arbitrator, these, my lord, are perhaps not to be considered for various reasons which have been laid down by your lordships. Now, my lord, if I may come to the judgments. No, we must show some judgments. তুমি এগুলো বার করো।
তুমি স্টাডি দেখো।
হ্যাঁ, এটা বার করো। First চারটে। First we'll start with PAM.
PAM তো আছে। তারপরে নেক্সট কি আছে?
So, my lord, to summarize the position really,
কোন চারটে? কি লেখা আছে?
Commercial Court, my lord, in those 3 paragraphs looks at everything. even in the grounds of appeal before your lordship, there is no real criticism that the finding of the commercial court was wrong, to the extent that we did argue these issues before the arbitrator.
Yes.
But for example, ground I, ground J, there is no ground taken that yes, these no damage clauses were placed before the arbitrator. But the arbitrator did not consider them. I have shown that in one paragraph the arbitrator has actually considered. There are plenty of other grounds, but the fact that these were not considered by the arbitrator doesn't seem to be a subject to correction, a aggrievement of the appellant. Now, Milord, I have threefold submissions. Number one is that on a construction of the clauses, or on a reading of the clauses, it becomes clear that the bar is for the corporation. Except the interest bar. The bar is for the corporation and not for the arbitrator. Except the interest bar, bar to interest. Number two, where bar to interest is really given a go-by the claim for interest made by the respondent. And number three, in the event of the respondent being, alternatively, in the event of the respondent being in breach, respondent in the arbitration being in breach, they are not entitled to take advantage of these clauses. Number four. So 3 is blood, respondent in breach can't take advantage of these clauses. Number 4 is it's a well-reasoned award. Technical matters which is paramount in an arbitration, quantification of claim, etc., all taken into account, all evidence analyzed, detailed procedure followed. Such an award would not shock your lordship's conscience, and these issues raised today would not be within the scope of section 34. And lastly, these grounds cannot be raised at all. A, not having been raised in the section 16 subsection 3 stage, and B, not having been argued before the arbitrator or pressed into service. Now these are the essential contentions, my lord. Your lordship, lordship has discontinued that Calcutta practice which your lordship started.
Here sometimes
12 o'clock normally. Now everybody gets up at 12.
Yes, here sometimes work is over at 10:35.
So the days when we are here then, or my...
We'll carry on.
We carry on.
We'll try and finish.
Yes. So my lord, now in Calcutta, my lord, everybody gets up at around 12.
I believe it's become a half an hour break sometimes. Yes, it used to be a 3-minute break for medical purposes.
5 minutes. Your Lordship used to get up for 5 minutes. Lordship and Justice Dotto.
Justice Dotto and I used to get up. Yes. And we used to compensate it by sitting beyond 1:15 and even after 4:30.
So much of work we did then. They don't understand. In fact, my learned friend hasn't seen your Lordship. So I said that 100 matters in the interlocutory court. I used to be ready. I used to read up to 80 thoroughly, unless every morning is a revision session, unless there is, that there is a big adjourn motion which will go on for a day. 100 matters.
My secretary came to invite me for his wedding. He said that your count was in hundreds and above. Here the count is in single digits now.
That is true.
There have been days where new motion in the company court or arbitration have been 300 or so.
Company court was more. Company court, we used to be very scared it would cross 150. After a certain number, we would give up. It's not possible to be ready in so many. You get confused being ready in so many matters. Most dangerous day was monthly list day. First Monday of the month was the most dangerous day. Especially if your Lordship came into interlocutory court.
Let's go deep into adjourn motion.
Yes. That was a very dangerous day.
Interim stage there, 3 days hearing going on.
But I admit that life is peaceful. But sometimes you miss it also.
Yes.
Now, my Lord, on those 4 issues, my Lord, I'll quickly first go into PAM development, which is reported at.
We are doing it in a wrong order, so to say, because Mr. Jindal just pointed out those clauses and thereafter we did not let him make any submission. So he really, and we called upon you, why should we not set aside the award on these grounds? So why don't we give him a chance to finish his argument, to cite what he wants to cite, so that it can be in proper order now.
I'm grateful.
My learned friend has.
First, Mr. Jindal, you take us to Section 34 and tell us which limb of Section 34 are you relying on?
Yes, it's only ground public policy. What does the public policy means that has been defined in associate builders and swap agreements? And fundamental policy of Indian.
You will be in very great difficulty if you hang it on that peg. You will be in great difficulty if you hang it on that peg.
And also on Section 34, Clause Roman 4.
Roman 4, what is that?
I'm sorry, Lordship, Roman 5.
Roman 5. The composition
of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties.
Why? What? This point you've never taken.
Lordship.
What was the composition? How was the composition wrong?
No, Lordship, I'm just reading it full. Unless such agreement was in conflict with the provision of this part from which the party cannot derogate, or failing such agreement was not in accordance with this part, last part, Your Lordship, that the arbitral award was not in accordance with this.
What are you saying? Read the clause. This only pertains to composition
Yes,
and
Lordship.
nothing else,
Yes.
not on merits.
Less Lordship. Then comes to Your Lordship clause B, which says that subject matter of the dispute is not capable of settlement by arbitration.
How is it not capable of settlement? How is it not arbitrable?
It is arbitrable, Lordship.
Then
It is
clause 1 deals with arbitrability.
Yes, Lordship. Yes, Lordship. Now, the only ground then remains the public policy.
Now, award is in conflict with public policy. Then what is public policy? There is an explanation.
Yes. For the avoidance of any doubt, it is clarified that an award is in conflict with the public policy of India only if the making of the award was induced or affected by fraud or corruption, or was in violation of Section 75 or Section 81, or is in conduct.
What are you reading? The rest of it does not apply to you.
No, Lordship clause, subclause 2. It is in contravention of the fundamental
It does
policy.
not apply to you. Yours is a pre-amendment award.
Pre-amendment before 2015. Before 2015.
Yes. So the provision was different.
I'm extremely sorry, Lordship. I am reading 9. Can you give me?
Read the footnote in that book itself, that page.
Yes, Lordship. Yes. Explanation. Without prejudice to the generality of subclause 2, it is hereby declared for the avoidance of any doubt that an award is in conflict with the public policy of India if the making of the award was induced or effected by fraud or corruption or was in violation of Section 75 or Section 81. Your Lordship, my submission is this, Your Lordship, that the concept of the public policy has been well defined.
Very well. So you are not on the other part, only public policy. Let us see. So therefore we'll...
Lordship,
just a second. 34 2B2. Yes.
Yes. Lordship, my learned friend has read certain prohibitory clauses. Only 2 or 3 clauses he has missed. I will just point out those clauses, Your Lordship, which he has missed. Lordship will come to clause 54, Roman 5, page 238.
$50?
238.
Clause
54.
Where is clause 54 referred to in your pleadings? Before the arbitrator. Where is 54 referred to in your pleadings before the arbitrator?
It is not there.
Forget it then.
Confine
yourself to what was before the arbitration.
Your Lordship, let me just go through the pleadings. Give me a chance to refer to the pleadings. What is there?
Refer to what is referred in the pleadings.
Yes.
Which clauses are referred to in the pleadings?
Yes, Lordship.
This is not a banyan tree adjudication.
Your Lordship will come to page 381. That is my sir rebuttal.
$381.
381.
381 is a verification page.
Of memo of appeal, annexure 15.
381 or 382?
381, starts from 381.
Yes.
Your Lordship, I am reading para 4.
Just one second. Page 385, paragraph 4.
4. I am reading the last sentence. The claimant having entered into
24/7. Your reference over there is to clause 24/7.
7
24/7 BII.
i.e. read with clause 20.
Where? I read with clause 20.
The claimant having entered into a solemn agreement
Yes, very good. Show us
was
the
bound by the
other
clauses
references.
contained therein.
Show us the other references.
Yes, Lordship. Para 8.
Para 8 is again the same.
Same.
Para
There
8
is
is
no
also
question
same.
of compensation. Then your Lordship, para 30. 30.
Para 30 is again the same. 24 read with 20.
Yes.
And
Para 30.
Anywhere else?
Yes, Lordship. Then your Lordship will come to my written submission, page 435.
Page 435.
Page 435.
Yes.
I am referring to relevant page 443.
443, yes.
443, paragraph 16. The exercise for, this is my written submission, Lordship, before the arbitrator. The exercise for quantification on claim number 1.
No. This is not referring to any clause, sir. Show us, we want to see which of the clauses you have invoked to tell the arbitrator you are not authorized to grant this claim.
Yes, Lordship, this is only with regard to
Nothing
24.
more in that
Just
page.
allow me to read paragraph 16, Lordship.
18.
16. The exercise for quantification on claim number 1 done by the respondent so far is in compliance with the order of the Honorable Tribunal.
And the tribunal has taken into consideration.
Yes.
Despite this submission being not without prejudice,
Yes.
the tribunal, when it awards it, has recorded without prejudice.
Without prejudice.
So that point is taken into account.
Yes.
You come to the contractual provisions,
Yes, Lordship.
which is there once again in paragraph 18, clauses 24 and 74.
24 and 74.
Para 18, clause 24 and 74.
74.
So therefore you have
A case under
made out a case only under
clause 24,
24,
5,
20, 24 and 74.
74.
And clause 20 naturally.
Clause 20.
Yes.
And one thing more, Your Lordship, so far the award on the DG set is concerned, there is a specific provision in the contract which debars such a claim.
Anyway, you have not pointed that out. We are not going to look into that.
Of course, that I have not pointed out before the arbitrator. But before awarding the claim, it was expected from the arbitrator to go to the contract agreement, Your Lordship.
If you don't assert it, it's no obligation of the arbitrator to look into it. You have to assert it. You have asserted these. Let us see to what extent they nullify the award.
Yes, Lordship.
Let us come to those clauses. Come to clause 20.
4, Roman 7.
No, first come to clause 20. 20, 24 and 74.
4.
So come to clause 20 first. 20 is suspension of work.
Yes, Lordship. This applies only in the case of suspension of work.
The contract is suspend the work. Right?
Suspend the work and it is admitted
during such suspension and properly protect and secure. Otherwise, provide necessary by reason proper execution of safety of the works, but thereof. Clause 20 to determination engineer following the suspension. Persons after shall determine extension and amount. So therefore, there is no suspension over here.
No suspension.
So therefore, clause 20 will not apply.
Clause 20 will not apply. 24(7) will apply. Roman 7 would.
Let us go. No. Why I am saying this? Because in two distinct places you have said red with 20.
Yes, Lord.
20 does not apply at all. Because there is no suspension.
Then your Lordship, 24(7) is at page 200. Seven. No compensation is admissible other than whatever provided for in the clause number 20, suspension of work for any extension of time if granted.
So this prohibition is confined to extension of time only.
Yeah.
And nothing else.
Nothing else, Lordship. In this case, your Lordship, the contract period was from 31/8/2009 to 31/8/2012.
Just one second. Give us 1 minute, please. Yes, sir.
The contract period was from 31/8/2009 to 31/8/2012. And the claim in question is for the period from 31/8/2009 to 30/6/2011.
Within the contract period.
Within the contract period.
Yes.
Now, before filing this claim, contractor sought extension of time.
Yes.
On 2 occasions.
Yes.
And respondents have granted extension of time first extension was granted up to 28/7/2012 and second extension was granted up to 27/8/2013.
27/8/2013. And previous extension was
up to 28/7/2012. Lordship may have looked at page 556.
How can it be? The contract ends at 31/8/2012. How can you grant extension on 28 up to 28/7/12?
No, sorry, Lordship. By this letter it was granted, and the extension was granted from 31/8/2012 to 31/8/2013. My mistake, Lordship.
31/8/2013.
And the second extension was granted on 27/8/2013 from 1/9/2013 to 31/7/2014.
Very good.
There is no dispute about this. They have admitted also.
Yes.
Admitted also. Now, claim of the contractor, your Lordship, is that because of these hindrances, this work was delayed and they were bound to take extension of time. And therefore, For the purpose of granting extension of time, exercise was carried out between both the parties. Delays were ascertained, that how much delay is on the part of the owner, how much delay is on the part of the contractor, and what are the delays which are not.
Now, Mr. General, over here must be very clear. When it comes to the merits of a claim.
Yes, Lordship.
Before an arbitrator.
Lordship.
The only way that you can succeed in Section 34 is by showing that the contract prohibited the claim from being entertained.
Yes, Lordship.
Now, over here, those clauses that you have cited before the arbitrator do not expressly provide for the claim not to be entertained.
Yes, Lordship.
Your argument now is that they were granted extension, they were granted more money for extension.
Yes.
Therefore, this is a duplication of the claim.
Yes, Lordship.
This is a matter which the court cannot go into. This is a matter only for the arbitrator. This is not a bar by the contract, but this is a bar by reasoning. This is completely beyond judicial review under 34.
Lordship. So, the claim is only, the plea is
We
only.
follow what you're saying. That is duplication.
Duplication.
That once you've granted extension of time,
Yes.
once you've paid more money for extension of time,
Yes, Lord.
then there couldn't have been any claim for the period prior to the extension.
Prior to the extension.
But that is something that is not prohibited by contract. That is something which is within the exclusive domain of the arbitrator. And as you know, error of jurisdiction is corrected. Error within jurisdiction cannot be corrected.
Lordship. Then your Lordship may have a look on 74E.
74E.
E.
Then it becomes very simple. Then we don't even need any judgment. 74E is at which page, sir?
I'm just thinking. Page 261.
Price variation.
261.
261. No claim whatsoever for price adjustment variation other than those stipulated above shall be entertained.
Yes. Now you come to
74.
74. If clause E
Yes.
had been a single standing clause, clause 78 or something, towards the end of the contract, but was not part of 74, your argument could have been countenanced. That would have meant no claim except for what is stated above will be entertained. But clause E is part of 74, and 74 is confined to price adjustment, which is labor cost in local currency, diesel cost, and things like that.
Yes,
Come to page 258. Payment to contractors for work done shall be adjusted for increase or decrease in local currency cost of labor, material, high-speed diesel, except those supplied.
Lordship.
So it's confined to that. If the clause is confined to that, the prohibition at the foot of the clause has necessarily to be confined to that and does not extend beyond that.
Lordship.
So there's no claim on account of price adjustment it's for idle labor. Price adjustment would have been, I have calculated 10 rupees 2 annas for price, whereas because of increase it's become 11 rupees 4 annas. It's not on account of that. It's for idle labor, idle machinery,
Lordship.
idle workforce and overheads. And what they have done is, they've said that we should have worked. If we have worked, got value of the work done up to this level as indicated in the contract, then the cost of labor, you see what? You indicate that the total value of a contract is, let's say, 300 rupees. You say every day we will do 10 rupees amount of work. So the contractor, based on that promise in the contract, organizes his labor, organizes his material, so that every day he can do 10 rupees work of the contract. So he organized 10 laborer, each of whom will take 50 paisa. He has organized material, the cost of it will be the rest of the 15 rupees. Now you, for reasons not attributable to the contractor, that work is not performed.
Lordship.
So the 10 laborers that he has got, he has to pay them. But the work is not performed.
Lordship.
So he is charging you for the cost that he has suffered because of the projection of the work in the contract, but which work could not be done due to no fault attributable to him. We are not supposed to analyze it, but we are just trying to explain to you what is the head of claim. The head of claim is not price adjustment. It's not price variation. It's not rate variation. It's not rate fluctuation. It's idle labor, idle employee, idle overheads because of commensurate quantum of work not being done as a consequence of reasons not attributable to him. Yes, anything else?
Lordship, only while doing the quantification, there is not much basis that on what
they have gone on the basis of a 68% reduction factor. You have disputed a 68% reduction factor. So what has happened is they have, I think, taken the claim and reduced it, taken the entire quantum of work and reduced it by 32%, I think.
32%.
Because 100 minus 68 is 32, it roughly comes to 1/3 of that. That is what they've done. You had said that the reduction factor should be at least 75, if not
yes,
more.
That 75% is inflated.
75% inflated. Over there, that's completely within his domain. He accepted that. Finally, what he said that you were supposed to give a corrected calculation on 28th of August of that particular year, which you did not submit.
Yes, Lordship, that is there on the record. And Your Lordship, we have filed SOD, we have filed survival. On the top of it is that arbitrator has asked us to give
we accept that.
Comments.
We are merely by filing your comment does not mean you are accepting. We accept that. That we don't question you on that. We accept that you have a objection on the ground of the head of the claim.
Yes.
And without prejudice to your objection as to the head of the claim, you've gone into quantification to show that it's a bogus claim.
Yes.
We are not doubting that. We are not doubting that. But what we are saying is that unless the contract prohibits, that is not there. And whatever is opposed to public policy, whatever you will show, will be, even if you go to saw pipes, where saw pipes went from 34 to 28,
yes,
to indicate what is opposed to public policy. What is opposed to public policy according to saw pipes is what is not in accordance with the law in the country.
Yes.
And what is not in accordance with the law in the country is
and
when a contract prohibits. Then that is not, if you grant in derogation of that prohibition,
yes,
it is not in law accordance with the law. But over here you can't show any clause.
Only Your Lordship, one thing about the DG set.
About
DG set.
DG set, sir.
Lordship, that plea, of course, before the arbitrator was not
if
taken.
the plea was not taken, we can't allow you.
Lordship, I have cited one judgment on the last occasions that even if a plea was not taken...
Yes, this is Himakuli, we know that.
Yes.
That's contrary to 200 other judgments. You want us to say that? It's contrary to 200 judgments said every day.
That was
elementary.
That was the latest judgment which I could find. And
let us see that judgment. We'll finish off that judgment in a minute. You find out something, which is Mr. Chaudhary, just counter this. There are hundreds of judgments which are of single judges which are contrary.
Your Lordship, last time I had given one compilation.
Yes. So we are only recording this one citation.
State of Chhattisgarh versus.
Where she said that even if ground not taken before the, let us see, State of Chhattisgarh versus.
That is how we distinguish.
Versus Sal Udyog Private Limited.
This is the judgment that you're referring to, 2022. Yes, let us see that. 2022 to SCC 275.
Paragraph 24, Lordship.
24.
Yes.
Come to the Arbitration Act. You probably have the same book. Come to page 34.
Yes, section 34.
34. 2 capital A.
2 capital A.
Can you see?
Yes.
Inserted by amendment.
This is by amendment. This is by amendment.
That does not apply to your case.
Lordship, yes. No, lastly it says, therefore it does not stand to reason that the provision that.
Please come to paragraph 24.
Yes, Lordship.
We are reading it for you.
Yes.
We are afraid that the plea of waiver taken against the appellant state on the ground that it did not raise such an objection in the ground spelled out in 34 is therefore stopped from taking the same in the appeal would not also be available. Having regard to the language used in 34(2)(a), which will not be applicable to your case, that empowers the court to set aside an award.
Yes.
Once the appellant had taken such a ground in the 37, it was duly noted in the impugned judgment of the High Court ought to have interfered under 34(2)(a) of the Act, a provision which would be equally available for an application to an appellable order under 37. In other words, it cannot be heard to say subsection entirely on 2A, and 2A was non-existent at the time of your award.
About the interest, Your Lordship, I am not.
About interest, they are not pressing. Pendent delay interest, they are not pressing.
Just to assist Your Lordship and my learned senior friend, in this matter, paragraph 23, objection was raised before the arbitrator. Objection was twofold: A, contract; B, circular. Paragraph 23. On a
Did raise an objection? I have encircled that.
So this
Second line did raise an
That's
objection.
a different point. It was ignored really. Grateful to Your Lordship.
Finish it, brother. The appellant herein engaged the respondent for the construction of a power project that goes by the name of Pemu. Pare in Arunachal.
Yes, my lord. Papum Pari in Arunachal.
Pare in Arunachal Pradesh. Full stop. There is no dispute that the hydroelectricity project is now fully functional, though the work was completed some 2 years beyond the original estimated period of 3 years. Full stop. Paragraph. The letter of intent in this case was issued to the respondent contractor on August 31, 2009, indicating that the tenure of the contract would be 36 months from such date. Full stop. The claim in the arbitral reference was for the period August 31, 2009 to June 30, 2011, primarily on account of the estimated work projected to be completed during such period not having been undertaken. Full stop. The various heads of claim were on account of idle labor, idle overhead expenditure, idle cost of employees and machinery, and the like. Full stop. The tenure of the contract was extended, first by a letter of July 28, 2012 till the end of August 2013, and next, by a letter of August 27, 2013 till the end of July 2014. Paragraph. The appellant employer contends that in view of the extension of time given to the contractor to complete the work, additional payments were made on account of cost overruns and other heads, and as such, the contractor could have had no claim on account of the failure to adhere to the extent of work projected to be completed by the contract during the original tenure of the contract. Full stop. Paragraph. On the appellant being pressed as to the specific ground under Section 34 of the Arbitration and Conciliation Act 1996 that it seeks to assail the arbitral award of September 15, 2015, it is submitted that in terms of Section 34, 34 bracket 2, bracket B, bracket II of the statute, of the said statute, the arbitral award is in conflict with the policy of India. Full stop. To boot, it is asserted on behalf of the appellant that the explanation that stood at the relevant point of time prior to the Act being amended in 2016, referred to certain aspects being covered by the expression open court in conflict with the public policy of India, close quote. But the opening words of the explanation, E capital, did not interfere with the generality of the relevant clause, full stop. In other words, the appellant submits that whatever may be contained in the rest of the explanation, the opening words of the explanation to the relevant subclause indicates that the explanation did not detract from the generality of what the relevant subclause implies. Full stop. The paragraph. The appellant amplifies the argument by referring to section 28 of the Act and relying on the principle recognized in one of the earlier decisions under section 34 of the Act rendered in Saw Pipes versus ONGC. I'll give you the reference. Full stop. According to the appellant, an award will be opposed to the public policy of India if such award is in conflict with the laws of India. Full stop. The appellant goes on to suggest that when a contract between the parties prohibits certain claims from being entertained or certain claims from being awarded, the disregarding an award in derogation of such contractual prohibition would amount to an act which was opposed to the public policy of India. Full stop. Paragraph. For such purpose, the respondent refers to its, for such purpose, the appellant refers to its pleadings before the arbitrator, including its written notes of submission submitted in course of the reference. Full stop. It appears from a surre rejoinder, S-U-R-R-E rejoinder, a surre rejoinder filed by the appellant before the arbitrator, that it referred to clause 24 bracket VI of the contract being a bar in the several heads of claim fashioned by the contractor. Full stop. Such reference is clearly found in paragraph 4 of the relevant document, where clause 24 bracket VII, small VII, is invoked in conjunction with clause 20 of the contract, of the matrix contract between the parties. Full stop. The same objection is repeated in paragraphs 8 and 30 of the relevant document, full stop. The appellant also refers to its submission, written submissions, one of its written submissions filed, which appears at page 435 of the appeal papers, full stop. At paragraph 18 of the relevant document, comma, clauses 24 and 74 of the contract are specifically referred to, full stop. The appellant accepts that apart from the aforesaid references, comma, there is nothing else in the pleadings or other documents filed on behalf of the appellant to question the claim of the contractor on any of the grounds of prohibition incorporated in the contract, full stop. Paragraph. In this context, comma, it is necessary to look into the three clauses expressly referred to by the appellant in course of the reference as prohibiting the claimant from making the claim that was carried to the reference and from the arbitrator even taking up such matter for consideration, comma, far less awarding any part of such claim, full stop. Clause 20 of the contract pertain to suspension of work, full stop. Such clause recorded that if there was any suspension of work at the behest of the engineer in charge, comma, certain consequences would follow, full stop. These consequences included extension of work and additional payments to be made to the contractor for the suspension of the work, full stop. However, comma, it is the admitted position that there was no suspension of work under the contract in the present case, full stop. As such, comma, section 20 of the contract would have no manner of application in the context of the claim that was carried by the contractor to the reference or the award that was rendered thereon. Paragraph. Clause 24 of the contract pertains to completion time and extension, full stop. Thus, comma, the scope of the clause is confined to the time by which the tenure of the contract is extended, full stop. In such context, comma, clause 24 bracket VII provides as follows, provided as follows. Next line, colon, open quote. No compensation is admissible other than whatever provided for in the clause C capital number NO 20 bracket suspension of work S capital W capital bracket closed for any extension of time, comma, if granted, full stop, close quote. Quite plainly, comma, the relevant subclause would apply only in case of any extension of time, comma, should such extension be granted Further, the extension of time contemplated in clause 24E, 24VII would have to be in connection with the suspension of work, as clause 20 is specifically referred to in the provision. Full stop. Thus, since there was no suspension of work and no extension as a consequence of suspension, clause 24 bracket VII of the contract was not attracted at all. Full stop. Paragraph. Clause 74E of the contract between the parties clause 74 of the contract between the parties pertain to price adjustment and variation. Full stop. Indeed, the opening limb of such contract referred to fluctuation in the cost of labor, material, high-speed diesel and the like, except for materials supplied by the employer to the contractor. Full stop. The second subclause in the relevant clause spelled out a formula for the price adjustment or variation that the contractor would be entitled to consequent upon the fluctuation of the relevant rates. Full stop. The last limb of clause 74 provided as follows, next line, open quote, no claim, whatsoever, for price adjustment, PA capital, stroke variation, V capital, other than those stipulated above, shall be entertained. Full stop. Paragraph. The above subclause, bracket E, is a part of clause 74 of the contract, was a part of clause 74 of the contract, and its effect had necessarily to be confined to the clause rather than the entirety of the contract. Full stop. It would have been a completely different kettle of fish if clause 74E were to be a standalone, independent clause that would have governed all the preceding clauses in the contract. Full stop. However, as noticed above, clause 74E merely qualified the foregoing provisions in clause 74 of the contract. Full stop. Paragraph. The claim in this case that was carried by the contractor had three main heads. Reimbursement for reduced functioning from the inception of the contract till June 30, 2011, semicolon, reimbursement of entry tax, semicolon, and comma, claim on account of reinforced steel used in precast RCC lagging, full stop. On account of the reimbursement of additional costs incurred, comma, inter alia, comma, on account of idle hired machinery, comma, underutilization of officers and staff, comma, underutilization of labor, and expenses at site and office on unachieved work, comma, the claim carried to the reference was in excess of rupees 40 crore. The claim on account of entry tax was in excess of rupees 1.67 crore, and that for reinforced steel was in excess of rupees 5 crore. Full stop. The second and third heads of claim dash on account of entry tax and reinforced steel dash were rejected, and the claim in excess of rupees 40 crore on account of the desired level of on account of the projected level of work not being done till June 30, 2011 was scaled down to slightly over rupees 23 crore, for which an award was made. Award has been made. Full stop. At this stage, comma, paragraph, it is necessary to refer to the other aspect, comma, on which there is no dispute. Full stop. The arbitrator has awarded the principal sum together with interest. Full stop. The parties agree that the contract contained a clause prohibiting the arbitrator from awarding any interest. Full stop. As such, comma, the respondent employer has agreed that it will not press its claim for pendentalite interest.
No, the contractor will not.
The respondent contractor has submitted that it will not press for any interest other than for the post-award period. Full stop. The respondent will be bound by such submission made in course of the present proceedings. Full stop. Paragraph. As to the quantification of the claim, comma, the appellant refers to its comments on the quantification and submits that a rather inflated claim was made on such account. Full stop. The other, comma, more substantial, comma, part of the appellant's challenge to the award is that upon the contractor being paid additional money for the extended period that it was granted to complete the work, comma, there could have been no claim on account of the original tenure of the contract. Full stop. In plain words, comma, The assertion of the appellant on such count is that the claim is nothing but a duplication and the same should not have been allowed by the arbitrator. Full stop. Paragraph. It is possible that a claimant carries a bad claim to an arbitral reference. Full stop. However, a claim that is bad on merits may not be a claim that is prohibited by the contract. Full stop. In the present case, the ground that is urged under section 34 of the Act is that the award is opposed to the public policy of India on the ground that the arbitrator has exceeded his jurisdiction and has entered into a no-go territory despite the arbitrator being a creature of the same agreement which prohibits the very entertainment of certain heads of claim. Full stop. Paragraph. It is elementary that in this jurisdiction, the court is more excited with errors of jurisdiction rather than errors within jurisdiction. Full stop. Indeed, even faulty interpretations of law by an arbitrator is left untouched in course of a challenge to the award, unless the court finds, as a consequence, that there has been serious miscarriage of justice. Full stop. Whether the court strikes down any award or a part thereof on the ground that there is serious miscarriage of justice as a consequence of any error committed by the arbitrator, or whether any part of the award shocks the conscience of the court, it matters little since the consequence is the same. Full stop. However, what the court cannot do in exercise of the limited authority granted to it under section 34 of the Act is to sit in judgment over the arbitral award as in case of a regular appeal. Full stop. The reason for this is that since the parties had agreed to take their dispute resolution mechanism outside the sovereign field of the court and to a private forum, the court, on rebound, will not address the issues unless it finds manifest miscarriage of justice to the extent that shocks the conscience of the court. Full stop. Errors of law, of interpretation, and other kinds are within the authority of the arbitrator and are, more often than not, left uncorrected by the court in exercise of its authority under section 34 of the said Act. Full stop. Paragraph. The appellant herein had, without prejudice to its contention that the entire claim carried by the contractor was inadmissible, asserted that the contractor had attempted to inflate its claim by using a reduction factor of 68 which may not have been appropriate. Full stop. It appears from the records of the reference that on various aspects, the arbitrator wanted comments or notes to be filed by the parties, including on the aspect of quantification under the first head of claim on account of cost overrun, on account of additional costs incurred for commensurate work not being done. Full stop. It also appears that upon the employer objecting to the original quantification of the claim by the contractor, the contractor scaled it down to closer to what has been ultimately awarded. Full stop. Again, the arbitrator gave the employer an opportunity to deal with the modified quantification, but the employer failed to avail of the opportunity and did not file its comments to the modified quantification on the first head of claim filed by the contractor. Full stop. Paragraph. In course of appraising the claim and the quantum thereof, the arbitrator referred to a document that was called, open quote, the Book of Hindrances, close quote, by the parties, full stop. The parties apparently maintained such book to indicate to what extent work had been impeded on a particular day and the reasons for therefore, full stop. It is from such book of hindrances that it was discovered whether a day's work or a part of the day's work on any given day was lost because of any reason attributable to the contractor or to the employer or otherwise. Full stop. The contractor founded the claim on the basis that it was entitled to due compensation for the extent of work not being achieved as projected in the contract, provided there was no wrongdoing on the part of the contractor. Full stop. On the other hand, the contention of the employer before the reference was that only the delay attributable to the employer should be considered for the purpose of compensating the contractor. Full stop. What the employer meant was that if there was any delay that may not have been attributable to either the contractor or the employer, the contractor could not be compensated on such account. Full stop. Paragraph. Though in not so many words, the arbitrator reasoned that since a projected level of work had been indicated and such level of work was not met in a given month, on the basis of charts which are appended to the award itself, calculations were made as to the extent of damages that the contractor would be entitled to. Full stop. It may do well, in this context, to understand the basis of the claim and the award, therefore. Full stop. In simple terms, comma, the contractor claimed that for the purpose of achieving the extent of work that it was required to do within a particular time, comma, the contractor had to engage men and machinery for such purpose. Full stop. Upon the work not being done to the expected extent, comma, a part of the labor and machinery that the contractor had hired in anticipation of such resources being required, comma, were idle, for which the contractor had to bear the costs. But since no commensurate work was done, the contractor was not to be compensated. Full stop. It is such claim of the contractor which has been allowed by the arbitrator to the limited extent and without paying heed to the appellant's contention that the delay not attributable to the appellant should not be counted against the appellant. Full stop. Paragraph. The decision to such extent fell squarely within the domain of the arbitrator's authority, and the court, comma, in exercise of the power under section 34 of the award, does not look for missing dots or does not look for small mistakes with an intent to interfere with the award. Full stop. In fact, the mantra under section 34 of the Act, dash indeed, comma, as it has always been in this branch of law, comma, not comma, dash, is that the court will not interfere unless there is grave injustice occasioned to the party complaining. Full stop. Paragraph. The court of the first instance noticed that several of the grounds that were sought to be urged in course of the petition under section 34 of the Act may not have been presented before the arbitrator or may not have been incorporated in the grounds filed along with the petition to challenge the arbitral award. Full stop. The appellant asserts that it matters little whether a ground has been specifically taken in the petition under section 34 of the Act, as long as it can be demonstrated that a clause in the contract prohibited a particular head of claim which has been awarded by the arbitrator, which has been allowed by the arbitrator. Paragraph. In such context, comma, the appellant relies on a recent judgment reported at AIR, reported at 2022 2 SCC 275 bracket State of Chhattisgarh versus Sal Udyog bracket P bracket Limited. Full stop. Paragraph 24 of the judgment is pressed into service, colon, set out paragraph 24, full stop, paragraph. What cannot be lost sight of in the present case is that paragraph 23 of the report in Sal Udyog records that the objection on the ground of prohibition and contract was raised before the arbitral tribunal, but a ground in such regard was not specifically incorporated in the petition challenging the award. Full stop. It was in such context that the finding as rendered in paragraph 24 of the judgment came to be made. Full stop. In the present case, it has already been discussed that the only three clauses that were placed by way of prohibitionary provisions before the arbitrator were clauses 20, 24 and 74. As already noticed, none of such clauses can be read to amount as a prohibition on the arbitrator to entertain the claim on the first head as carried by the contractor to the reference. Full stop. Paragraph. In any event, the ratio decidendi in paragraph 24 of the judgment in Sai Udyog would be inapplicable in the present case, since the award in this case was rendered on September 15, 2015, and this matter would be governed by the provisions of the said Act of 1996 prior to its 2016 amendment. Full stop. Clause 2-A within bracket was inserted in section 34, subsection 2-A was inserted in section 34 of the Act by the 2016 amendment. Full stop. Paragraph. As a result, the judgment and order dated, what is the date of this?
25th October 22.
Dated October 25, 2022, are left untouched except that the award of interest in the award of September 15, 2015 is set aside for the pre-reference period and whatever may have been awarded as pendentalite interest. Full stop. This will not prevent the respondent herein to claim interest from the date of the award in accordance with section 31 of in accordance with law. Full stop. Paragraph. To clarify, the award of the principal sum is left uninterfered with. Full stop. The grounds of challenge carried by the appellant are found to be without merit. Full stop. Paragraph. W, whatever the number is, appeal number 2 of 2022 is disposed of with costs assessed at rupees 50,000 to be paid by the appellant to the respondent within 3 months from date, failing which it will carry interest at the same rate as provided for by the arbitrator for the post-award period. Full stop. Anything else?
Lord, Saw Pipes is 2003 5 SCC 705.
705, yes. 2003 5 SCC 705. Thank you.
Lordship, may kindly consider the cost if possible.
No, sir. Commercial matter. We've been very
At least,
sympathetic to a government company in awarding less cost. Commercial matter, you bleed if you carry a bad challenge.
little bit was allowed by your Lordship. May consider.
Ask him what the rule was. It multiplies every time you object.
My record is up to 5 lakhs. my lord.
Well, 30 lakhs has been accepted by Supreme Court in an interlocutory matter.
Yes. 5 lakhs. Surface stay. That surface action was stayed,
Surface action was stayed.
5 lakhs.
Your 5 lakh.
It could have been more, my lord. It was many years ago when we were rank juniors, so your lordship possibly had some sympathy and let it go.
No, this 30 lakh was just before lockdown, 2019, I think.
Yes.
When before Justice Nariman and he said
Sustained.
that should we add to that before they shut up. Where it says it was in
I know which one it is.
more upmarket than Old Post Office.
No, it goes like this. You know, upscale South Calcutta antique hand.
Yes, thank you.
Grateful.
Call on the next matter, please.
Item number 2.
How are we doing on the NPT road?
Yes, it is okay, my lord. Yes, it is okay, my lord.
Very well.
Only that portion, my lord, 9 kilometer, it has completed on February. Now, March, April, it is starting damaging that portion of road. Only 9 kilometer, my lord.
According to the petitioner, the work is otherwise progressing well on the NPT road, except the 9 kilometer stretch that had earlier been referred to. Full stop. The petitioner complains that though the relevant 9 kilometer stretch between
41, sorry, my lord, 32 to 41.
between 32 kilometer
To
and
41.
41 kilometer
Yes.
was completed in February 2023, it has already started to tear up
Yes, my lord.
and show signs of wearing, full stop. Paragraph, if such is the case, it would be alarming, full stop. It is completely unacceptable that a road would be repaired pre-monsoon in February and the road would not last even before the first pre-monsoon showers have surfaced, full stop. The state should look into the petitioner's grievance pertaining to the relevant 9 kilometer stretch and report when the matter appears next, a fortnight hence. Just on the 9 kilometer. Rest is happy. We'll dispose of the matter after this. Yes, call on the next
Item
one.
number 3.